is an introduction and fundamentals of intellectual property that discusses types, definitions, and examples. The lecture will have a particular focus on patents and allied policies. So before we head on to the actual talk, let me give a short introduction of who Andrea is. She is currently an intellectual property and technology specialist at Pinoy IP Works Incorporated, Philippines, with a background in physics and materials science and engineering. Her current line of work allows her to create research reports and claims analysis of patent and non-patent literature for patentability, novelty, and freedom to operate studies, and file patent applications with topics ranging from food processing, computer technology, electronics and communications technology, mining, pharmaceuticals, consumer goods, and others. She has also done valuation studies for early stage development technologies. She is steadfast in her belief that effective solutions to real world problems can stem from proper technology management, bridging the gap of local research and practical and robust assistance to society. And now, without further ado, I'll give the virtual floor to Andrea.
Hi everyone, good morning. So I hope you've had your coffee and thank you for joining us this weekend. I know it's early, but I hope you've had your breakfast and your coffee, and I hope everyone's staying safe. All right, so my presentation for today will be on the fundamentals of intellectual property. So let me just share my screen. So okay, hold on. This talk will be primarily on the, just basically fundamentals lang on intellectual property. So, so we can have an overview on on what to expect when it comes to intellectual property and the things that we can do with it, and the things that we can do with it, and other allied policies that might help us understand further in how to navigate the prosecution of intellectual property. So first, I would like to introduce our company. So I'm from Pinoy IP Works. So we are the intellectual property arm of Fortuna Narvaez and Salazar. And our team is comprised of experts in law, science, engineering, and design. So, and I'm included in one of those experts given my background in physics and material science. So our team, it's a really, really small team. So we have attorney Loste, which is our managing director, and we have 3 specialists. So I mean, myself included, we also have Mr. Carl Revelar, which is a physics, also an IP and tech specialist, and whose expertise in physics. We also have Mr. Carlo Verhel, whose expertise in biotechnology. So we're trying to round everything up such that all technologies are included, or it's a very, very inclusive venture. So what we do, basically, we want to enable Filipino communities to benefit from the value of their ideas. So that includes local R&D communities, Filipino businesses and startups like yourselves, as well as artists, designers, and individual inventors. And basically, mainly our advocacy is to make Filipino IP known globally. So we really deal with the creation, protection, and subsequent commercialization of IP that we can siphon from different research and development institutes, academic institutions like yourself, and other individual inventors. So our services include, of course, very, very, very IP relevant lang din. So we have IP search, patent applications, trademark application and prosecution, IP evaluation, and as well we also conduct trainings for those who are who want to know more about IP and what we can do with it. And yun lang. So that's our company. So for the presentation proper, so it's ano lang siya, it's kind of long kasi maraming IP, right? So basically the presentation is segmented into 4 parts. So first we have intellectual property rights, and then we'll go to patents, and then assessing patentability, and as well as what to do to prior patenting. What do we do? So that is the preliminary prior art search. and the tools that come along with it. So basically, okay, what is intellectual property? So it's an intangible asset kasi siya because it is a product of the human mind, or the fruits of human creativity and innovation. So that includes inventions, literary and artistic works, designs, brands. So these are intangible. These are basically ideas na na gagaling lang sa brain, parang gano'n. And ayun, with that, now that we know what intellectual property is, there are this so-called intellectual property rights. Now you have your how do you make it parang how do you acquire, or anong pwede mong gawin dun sa intellectual property na meron ka, sa idea na meron ka. So you can get intellectual property rights. So intellectual property rights are basically rights that is had by a person or by company or any other entity to have exclusive rights to own its own plans, to use its own plans, ideas, or other intangible assets without the word competition. And take note, it is may certain duration lang siya. Lahat sila may expiration date, or well, hindi naman lahat. Pero I mean, to some extent, meron expiration date yung intellectual property rights. Ayun. So also, various intellectual property systems are governed and protected by various laws and mechanisms. So iba-iba yung iba-iba ang laws governing different intellectual property rights. So I'll discuss these later in detail. So these are established and enforced through national law. So it's very jurisdictional. So iba yung laws for like the Philippines versus the US or versus Europe. And rights are transferable. So these can be transferable through mutual agreements and by contracts with third parties or like with other entities, and can be used as an essential part of your marketing and or branding. Ayun. So, okay. And then there are maraming kinds ng intellectual property rights. So again, kasi maraming products talaga ang human mind. So because of that, we can categorize it into different types. So you have your patents, which include yung inventions, utility models, and industrial design, which will be the main focus of this talk, which I think is also appropriate for your kasi I reckon you're all technology-based startups. So I think this is the most appropriate tool or information that you need to know. So you also have copyright, trademark, geographical indicators, trade secrets, as well as plant varieties. So let's start with patents. So what are patents in the first place? Oh, patents are any technical solution to a problem or a new way of doing something. So patents are just basically parang solutions to problems in the human endeavor. Take note, human. So these should be human problems. Ayun. And these include new and inventive products and processes. So patents are an exclusive right to an inventor or any maker to prevent others from making, selling, or using a new product or process. So ayun. Key here is product or process. Ayun. So that's for patents. I'll discuss them in detail later. So we'll proceed with trademarks. So trademarks are signs that are capable of being represented graphically. So dapat ito yung mga nakikita natin, naiintindihan natin. And that is used to distinguish goods and services of one undertaking from those of other undertakings. So yung signs natin are representations which utilize images, lines, or characters. So in order to render a registrable trademark, the graphic representation must be clear, precise, easy accessible, intelligible, and dapat naiintindihan talaga siya ng kung sino man yung nakakakita sa kanya. Ayun. Dapat naiintindihan siya ng public. And then, so, ano yung included sa trademarks, or anong pwedeng gawing trademarks? So you have your words, designs, letters, even the shape of goods and their packaging, slogans, colors, and even sounds. kasi dapat ang trademark kasi they're unique sila such that kapag nakita mo yung trademark or narinig mo yung trademark, associate mo sila sa isang certain type of good or service. So that's what yun yung role ng trademarks as an intellectual property right. And then however, ang exclusions of may exclusions din naman ng registrability of trademarks. Hindi man pwede na parang pag may naisip ka lang na word or kung merong ka mang naisip na idea for a trademark, it's subject pa rin naman to certain rules before it can be registered. So yung mga hindi na register would be yung mga non-distinctive such as single letters kasi it doesn't really convey anything, as well as descriptive such as like yung descriptive then also have generic, contrary to public policy or morality, anything prohibited by law, and anything that is made in bad faith. Okay, so those are the what do you call this? Ito yung mga exclusions for the registrability of trademarks. And then we'll proceed with the copyright. So basically, copyright, these are a right that protects the expression of ideas. Take note of the term expression of ideas, and it's not the idea or the knowledge per se. So this is why yung included sa copyrights would be yung mga literary works, dramatic works, musicals, anything in artistic nature. There are films as well, sound recordings, and broadcasts. So yung pinoprotect dito is the characteristics by which the author has made the theme personal. So depende yun sa author, or depende yun sa gumawa nung work na yun. O dun manggagaling yung idea nung ano yung pinoprotektahan nung copyright. So ayun. Ano naman yung nature of protection ng copyright? So for copyrights kasi, it allows you to have economic rights. So these include yung right to copy, right to distribute, and right to display, as well as to have digital or digital broadcasting or auto transmission. Also, it allows you to have dapat may kasama siyang parang, or at least understandably, meron siyang moral rights na included. Ayun. However, there's an exception for the use of copyrighted materials. So these include for private use, or if you're using it for research purposes, as well as if it's subject to criticism or review, such as yung mga nire-review na movies, ganon. And then we also have yung when you report it as part of current events, that's also excluded from copyright infringement, as well as any incidental inclusion of copyright protected work in another work. Ayun. So, and next is we have geographical indicators. So, geographical indicators are just sign used on goods that have a specific geographical origin. So, naka-indicate dito yung name of the place, the origin of the goods, without it is used to identify goods through the name of the town, region, or country. So, examples, we have champagne for sparkling wine. So, if you know, may kaakibat siya na parang, if you know, if this sparkling wine is from Champagne, alam mo that it signifies quality. It signifies that it is the best type of sparkling wine that you can get out in the market. Ayun. So unique yung qualities ng product mo because it is procured, or at least meron siyang geographical indicator that it came from a specific origin. And dapat when we use geographical indicators, dapat particular ka about the nature, or at least kung saan galing yung isang product mo. That's why it's used to distinguish products from its competitors, parang ganon. So ayun, example again is like for sparkling wine, champagne. For cheese, we have Parmesan cheese and Parma ham. So alam mo na galing siya sa Parma, Italy, as well as Florida oranges. Ayun. So this would help you to prevent infringement and unfair competition when you are commercializing your product out in the market. And then next is we have trade secrets. Now, for trade secrets naman, these are just parang business information lang siya that allows you to have an advantage over your competitors. So, despite meron lang siyang konting reasonable steps to allow it to be kept secret. However, unlike other IP rights, wala siyang procedural formalities na ginagawa. So, yung trade secrets, kapag lumabas siya out in the public, wala siyang protection. Ibig sabihin, once that information is out, it's public domain already. Ayun. So these include yung mga sa KFC, yung 11, I guess. Is it 11 secret spice blend, as well as yung recipe for Coke. Ayun. And then last is we have yung plant variety. Now, plant variety is just used as an exclusive right for breeders lang din para makita mo yung para ma-identify mo lang yung variety ng plants once na, let's say, nagkaroon ka ng bagong you found new plant variety. So lang siya, parang it's more of an acknowledgement that there's a new plant variety that is created or discovered. Ayun. So however, may criteria din siya sinasatisfy before you can dub it as a new discovery of a plant. Ayun. So in summary lang, itong apat na to, these are the more pertinent IP rights that we know of. So iba-iba sila ng, again, for IP rights, lang siya, it's only protected for a certain duration, right? So for patents, meron kang up to 20 years na protection. For copyright naman, up to 50 years after the death of the creator. And then trademarks, 10 years, but it's always renewable naman. And for geographical indicators, forever siya, pero dapat there is proof na yung product na yon is really coming from that specific area. Ayun. So yung subject or at least yung information na pinoprotektahan ng patents is, for one, is yung pinoprotektahan ng patents is yung idea or ng isang process or system or composition, which I will discuss later in detail. For copyright naman, these are the expressions of literary and artistic works. For trademarks naman, signs and marks that are used for trade or for in marketing and branding, pag you're using it for transactions. Ayun. And for geographical indicators, these are signs used to indicate place or area of origin. And are there registration needed ba for these IP rights? For patents, of course, meron. Kasi it's subject to prosecution, so it's mandated by law na dapat you undergo, if you want patent protection, it undergoes a certain process that's governed by law. There are laws that govern this. Ayun, so you have to have it registered. For copyright kasi, no. Bakit? Ang copyright kasi, it's actually, ang meron kang copyright once you create that work or that artistic work. So once nagawa mo siya, meron na siyang parang applied na copyright. However, you can always get naman a certificate for copyright from let's say here you can get a certificate of copyright from the National Library or the Intellectual Property Office of the Philippines. If you want proof na ikaw nga talaga yung naunang gumawa ng art ng work na yun. For trademarks din, it is generally registered. However, sometimes hindi siya na-register, pero it's always advised na i-register siya. And for geographical indicators, yes, you have to have it registered kasi it's needed as proof na that product is from a certain or particular area lang, or area. Ayun. So, do we have questions so far? Hello.
I think we can proceed with the rest of the talk, Andrea. We'll have the question and answer portion once you're done.
Okay, sige. So, oops. Hold on. All right. So, okay. Now that we know the at least pahapyaw lang ng types ng intellectual property rights that we have, we'll proceed with patents. I think this is the more relevant, or at least relevant na IP rights that is more applicable sa inyong technologies or inyong products. So, just a brief history of the patent system that we have right now. So, one of the first few indicators that there is parang patent law was from Venice in 1474. So, from the state of Venice stated that any person, in the code, any person in the city who makes any new or ingenious contrivance not made herefore in our dominion shall as soon as it is perfected. So, oh wait. Anyway, just to cut it short, ano lang siya, parang pag nagkaroon ka ng if you created something or a new invention, parang ganon, it can be protected up to 10 years. So you're forbidding other people from using that said technology for their own exploitation. Ayun. So this has been refined by the Paris Convention for the Protection of Industrial Property in 1883, and then a more you call this, parang mas comprehensive na agreement, or mas comprehensive na rules for intellectual property protection was ratified in the TRIPS agreement in 1997. Ayun. So the current patent system that we have here in the Philippines naman, we follow certain policies that are parang ginawa dito sa Philippines in alignment dun din sa World Intellectual Property Organization natin that govern the prosecution and maintenance of patents. So that include yung Intellectual Property Code of the Philippines, or RA 8293. We also have yung Patent Law, RA 165. And these are governed by the Bureau of Patents of the IPO. And we also have Patent Cooperation Treaty, which allows yung members niya to file patents in other jurisdictions. Again, as you know, very jurisdictional lang patents, right? So, yung member states niya, once you're a member of the PCT convention, yung member states niya, you're allowed to file patents in other jurisdictions lang, depende kung saan ka mag-a-apply. Ayun. So, basically, the patent system has a threefold purpose. One is to seek to foster and reward innovation. Kasi, again, you're merely excluding other people to use your product, right, for their economic exploitation, perhaps. So, ikaw lang nakagamit doon. Ikaw lang yung pwedeng siguro kumita, or ikaw lang yung pwedeng mag-govern kung ano yung pwedeng gawin doon sa intellectual property rights mo. So, the next one is the disclosure of innovation to stimulate further innovation. Again, it's always used. We're always moving forward, or we're always moving along with the innovation of our technologies, and permit the public to practice invention once patent expires. Once a patent expires, kasi it becomes part of public domain, meaning it's made available for everyone to use. That's why laging may innovation. Kasi ayaw mo naman na parang stuck ka lang na kung ano ginagamit natin ngayon, yun na lang. Ayun. And the last one is to ensure that ideas in the public domain remain free for public use. So patent as a social contract. So again, a patent is a social contract where the applicant gets rights to exclude yung exclusion ng possible competitors, which is usually up to 20 years protection. So this allows the bargaining, this encourages the creation and disclosure of new, useful, and non-obvious advances. That's why lagi may competition for like different technological companies. Let's say for Apple, or like for Samsung, laging may advances in their devices or in their products, and they usually protect it via patenting. So, okay, so now that we have like a brief history of what patent is and ano nga ba talaga ang patent? So, a patent is a negative right kasi you prevent others from exploiting the invention, and it's always first to file. Again, kasi you need proof na ikaw yung unang gumawa nun. So, let's say marami kayong gumawa. Ang laging kino-consider lang for the patent protection is kung sino yung unang nag-file ng patent application. So, it's not always kung sino yung unang nag-invent. So, it's a race. Ayun. And, so, this also, meron, usually meron din namang overlap between your patents with others, pero meron din namang wala. So, with patenting, malalaman mo kung may overlap ba, or has this technology been done by other entities or hindi pa. So from the patent examination, malalaman mo kung mayroong overlap. And then ayun, so I'm not sure, has anyone seen a patent document before? Wala. Okay, sige. So what do patent documents look like? So basically, it's parang you can segment it to various parts. So this is an example of a US patent. Iba yung form iba din naman yung itsura nung sa patents natin here in the Philippines. Pero basically, patents would always have yung bibliographic information. I'm not sure if you can actually see yung yung contents niya, but you can see yung title. You can see the title, the patent number, and date when it was filed. Kasi again, di ba, first to file tayo. So very particular ang patents when it comes to dates. Talaga. So we also have yung inventors, assignee, kung sino yung may-ari ng patent na yun. If the inventors are part of a certain organization, naka-indicate siya dun sa assignee. Unless it's an individual, this assignee would be the same with the inventors lang din. Ayun, and yung it also includes yung abstract, which basically summarizes yung ating patent. So that's a bibliographic information. So we also have yung specifications. Now, sa specifications, dito naka-detail yung patent, as in all its embodiments. Lahat nakalagay kung ano yung meron dun sa ano yung dinidiscuss ng patent na yun. So, nandun yung background, yung prior art na sinasabi natin, as well as yung detailed description ng invention or ng ating patent. And then lastly would be yung claims. Now, I would say claims are the most important part of patent kasi it serves as the border of the patent protection. So, parang ikaw yung claims mo kasi doon nakalagay kung ano talaga yung pinoprotektahan mo. Let's say you're protecting a method of, for this one, a method of receiving a post from a user. Ayun. So, yung methods that are included in that particular technology, lahat ng details na nandun, nakasummarize sa claims, and then that borders your, yun yung nagiging border natin for patent protection. So, once you set up your border right, doon mo malalaman how much you can exclude or include in your patent protection. So, ayun, there are also figures din. So, meron ding, depende rin naman sa ating gustong protektahan. So, for figures, pwede mong picturean yung system. For this example, we have Facebook. Actually, yes, Facebook has patents for their products. Even their interfaces, merong patents. And then, notice na merong numbers na naka-indicate dun sa or parang may parang arrows and numbers. Kasi whenever you draft patents or sa patent documents natin, yung parts niya naka-signify siya through numbers. That is for system patents. However, for chem patents naman, hindi naman siya necessary. Ayun, pero ayun, for may designated numbering din that allows you to really be particular of the parts or of the structural elements of your patents. So now that we know what patents look like, ano naman yung pwedeng i-patent? So again, may tatlong main criteria for patentability. So that includes yung novelty, o ibig sabihin it's new or bago siya in light of its prior art. I'll discuss prior art later. And it involves an inventive step, meaning hindi siya obvious, hindi obvious yung hindi obvious yung yung structural or functional elements niya with other existing prior art. And it should be industrially applicable. Again, dapat kaya siyang i-replicate ng tao. Kasi once a patent expires, it's public domain, pwede na siyang exploit ng ibang tao. Dapat nagagawa siya ng tao. Ayun. So, yun yung tatlong main criteria when it comes to patentability. Pero, there are topics that can and can't be patented. So, for what can be patented, so for there are things that we can patent, such as processes. So, there is process of use, process of manufacture. There are non-biological or microbiological entities, and as well as any improvement thereof. Yung improvement kasi, that would usually signify that something is inventive kasi it's para elevated siya as opposed to its prior art. We also have yung products then. So we have yung machines, devices, article of manufacture, composition of matter. So dito pumasok yung mga drugs or yung mga gamot, as well as microorganisms. You can also patent those and any improvement thereof then. And we also have computer-related inventions and any improvement thereof. So dito pumapasok yung mga AI, yung mga IoT. Ayun, kasi these are bago lang tong technologies na to. So they're trying to fortify pa yung laws for these, pero these can be patented na rin. However, there are things that can't be patented. Again, i-reiterate ko lang, patents are solutions. Solutions dapat sila, technical solutions to any human, to any problem of the human endeavor. So these don't include yung scientific discoveries, laws of nature, mathematical methods. Kasi ano yan, that's just concepts lang sila. So also we have abstract ideas, theories, fundamental concepts, schemes, rules, and methods of performing. Games, then you can't patent those. Methods of doing business, as well as computer programs. Now, computer programs can't be patented, pero if it's part of the hardware or it's part of something that allows hardware or system to function, then it can be patented. Pero computer programs per se, hindi. They can be ang kaakibat na IP rights for computer programs are copyright. Ayun. And as well as anything contrary to public order and morality. So these include yung, let's say, methods, yung, I don't know, like I guess this is very self-explanatory then. So you can patent those. So there are 3 types of patents then. So sila, iba-iba sila ng requirements. Although they should all be technically applicable, iba-iba sila ng protection and ano yung pinoprotect nila. So inventions, ang requirement dito ay una, dapat novel sila and they should be inventive. So yung protection natin dito ay 20 years. For utility models naman, ang only requirement for this is it's novel lang. And it's only protected for 7 years. And then for industrial design naman, so for industrial design, ang main na pinoprotektahan dito ay yung ornamental or aesthetic aspect of an article. So yung shape niya, yung itsura niya, yung shape niya, yung whatever patterns, lines, or colors na nandun sa ating article, yun lang yung pinoprotektahan. Yung features niya lang. So ang requirement lang dito is it's only required to be novel. And the protection is up to 15 years. Kasi it's 5 years and then renewable siya twice. So that's 15 years. So ayun, I've always mentioned na ano nga ba yung difference ng how do you assess patentability? So for this, meron tayong tinatawag na prior art. So we use this prior art to assess patentability. So prior art is basically any evidence that is made available to the public everywhere, whether it's written or an oral disclosure, that is before the filing or priority date. So, yung this include yung mga literature, patent documents din, ang kino-consider din dito is other published patents by API offices in other jurisdictions before filing date or priority date. Yung filing date is your filing date. Before ka mag-file, you check yung prior art mo. Now, how do you assess the patentability? Through the prior art. Oh, sorry. Ito rin, also one reminder din talaga for everyone. There is also this concept we call non-prejudicial disclosure. So this is a disclosure by an applicant or foreign patent office or any third party na yung disclosure na to, it's done, dapat mag-file ka ng patent after, before 12 months of filing date. Otherwise, once nag-lapse na yung 12 months na yun, 12 months na yun, from your original disclosure or your public disclosure, na siya, magiging public domain na siya. Magiging part na siya ng prior art. Magiging evidence na siya that that is available to the public domain that your technology has been done before. So we highly encourage that people or those who do research don't publish or sell before you file an application because once you publish, it's considered as a public disclosure na. You would only have 12 months before you can file an application. Otherwise, mahihirapan ka ng mag-prosecute ng application. Unless may improvements within that 12 months that you can incorporate in your patent application. Pero kung wala, we suggest that you don't publish or sell. However, we also highly encourage that you sign an NDA and seek advice and file ASAP. Yun yung lagi naming reminders for those who plan to commercialize a product or kung may results from may output from research and from a research study. Ayun, before you publish, file an application. So again, yung tatlong requirements natin, right? We have yung novelty, inventive step, and industrial applicability. So how do you assess yung novelty? So ang novelty lang kasi, meron tayong tinatawag na strict identity test. So ang isang novelty destroying na prior art, it would discuss each and every element of your disclosure. Let's say you have a technology for processing or for a new cell phone, ganon. And then you found a prior art that is very, very similar. And lahat ng parts niya, lahat ng functions niya, very much the same with that of your invention. Ano na siya? And novelty destroying na yon. Unless otherwise, let's say, may isang function yung prior art na phone na nawala doon sa current mong invention. Ibig sabihin, your invention is novel over the prior art. Pero once na lahat ng element na satisfy yung prior art with that as opposed to your disclosure, ibig sabihin, wala nang novelty. So hindi na siya patentable. Okay, what about naman yung inventiveness? So again, you compare your disclosure with that of the prior art. You deem a disclosure inventive if it is not obvious to a person skilled in the art, meaning it's an improvement or it's unexpected. Parang ganon, yung results mo unexpected with that of what is known out there. Ayun. So, ayun lang. So, medyo mahirap siyang gawin, pero in practice, nagagawa siya. Pero dapat, ang main criteria lang dito is yung obviousness. Meaning, let's say I'm an expert in, yung same example ng cellphone, hindi ko naisip na lagyan siya ng camera because it can't, yung prior art, walang camera, but your new invention has a camera. It's inventive because, let's say, hindi mo na naisip na lagyan ng camera yung bagong device. So that in itself is already inventive. Ayun. Dapat hindi siya obvious in light of the prior art, yung feature na yun. So, although mahirap siyang gawin, honestly, pero we can always follow a few steps naman. So first, may tinawag na this is what we do when we assess the inventive step or inventiveness of a disclosure. We do a problem-solution approach. Tas, ayun, bakit problem solution? Kasi di ba, patents are solutions to any human problem, parang ganun. So you check, first, you determine the closest prior art, meaning, is your prior art solving the same problem that you do, or that you have? Ayun. And next is to evaluate the difference between yung closest prior art mo and your disclosure or your invention. So ano yung difference nila in terms of like yung structural elements, yung functional elements, how much do they differ? And then identify mo kung yung problem na sinusolve nyo, how much of, balik ka doon sa problem, and then how much, ano yung difference nung pag-solve mo ng problem as opposed to dun sa pag-solve ng problem sa prior art. And then i-assess mo kung yung ano na yun, yung difference na yun, is it obvious to a person ordinarily skilled in the art? Ayun. Kasi if it's obvious, let's say, kung mere addition lang siya ng components, parang ganun, like, I guess, obvious na siya in that regard. Pero kung hindi unexpected na parang may unexpected result yung mere aggregation ng iyong setup, then that can be deemed as inventive na. So yun, these are just, ito lang yung parang 4 steps really on how to assess patentability. And then ayun. So yun lang yung may tatlong main criteria lang talaga na yun kailangan mong maintindihan for patenting. And now that meron ka ng patentable material for patentable information that you can file for an application for. First, how to obtain a patent here in the PH to ha. So you first request for grant, meaning magsasubmit ka na ngayong application. So yung naka-indicate dito is yung name, title, name ng inventors or ng applicants, yung title ng invention, and then yung address. And you should provide an enabling description of invention. Meaning, by enabling, we mean dapat intelligible siya, naintindihan siya, and dapat replicable siya. Dapat kung yung examiner dapat maintindihan yon, any other person who would read it maintindihan yon. And they should define yung cooperative structural relationship between elements, whether it's functional or structural elements. Dapat in synergistic yung interaction ng mga elements na yun. So, yung kaakibat din nito, once gumawa ka na ng detailed description of your invention, include mo na rin yung drawings, yung abstract, and finally yung claims. Yung claims yung talaga important dito. And then you pay for fees. So ayun. So once you pay for fees, subject na siya to subject na siya to patent examination procedures. So ayun. Ito yung basically overview ng patent prosecution procedure here in the Philippines, or at least here for IPO-Phil. So for step number 1, yun, yung request ko for grant, so magsasubmit ka, magbabayad ka ng fees. And then once na deemed na satisfy lahat ng requirements for a patent application, it's subject to formality examination report once an examiner is assigned to it. So dito sa formality examination report, indicate lang kung na-satisfy yung requirements, kung pasok ba siya doon sa format, or any formality deficiencies that you have, let's say lack of fees, very lang siya, standard lang siya. Ang important dito is yung examiner then would conduct prior art search. So gagawa na siya ng sarili niyang prior art to see if your technology or your application has been done, or at least may evidence na rin nagawa siya. So dito sa segment na to, gumagawa ng may written opinion yung examiner that assesses the patentability of your patent. And then after 18 months from the filing date, ipapublish na yung ating application. For step number 3, non-binding naman yung written opinion. So between you and the examiner lang, kayong dalawa lang nakakaalam kung ano yung findings ng examination report na yun. So, for fourth, ayun, magbabayad ka, may babayarang fees din. Along the way, may babayaran ka rin fees for patent prosecution. So, pinapublish na kasi i-check kung merong opposition from other third-party entities na that can raise points na, let's say, they might have patentability issues with your filed application. And 6 months after yung publication, you will have your substantive examination. Ito, mas yung written opinion dito mas comprehensive. So talagang lahat yung claims kasi ginagamit for examination reports. So i-check kung yung claims mo ay either novel, inventive, or industrially applicable. So mas comprehensive yung discussion dito kung if it satisfies the requirements for patentability. Once na-traverse na yun, once let's say it's new, and let's say na dito nagkakaroon ng correspondence between your representative or your inventor and the examiner. So nagkakaroon ng you submit letters in response sa opposition sa objections ng examiner para and then you amend the claims or specifications if necessary. And then once you've agreed upon a certain claim set na rin that would napasok na doon sa patentability requirements, pwede na magkaroon ng i-issue na yung patent certificate. And then once the patent certificate has been issued, ibig sabihin granted na yung iyong patent, unless otherwise magkakaroon pa ng third party opposition. And then let's say sa national phase, pasok na yung patent natin. What if gusto nating mag-file sa ibang jurisdictions? Now we have this thing called PCT filing system, which we are, kasi member tayo ng PCT treaty dito, sa buong mundo. So it allows us to file our patents in up to 153 countries, affording an application the same filing date in every jurisdiction. So yung i-consider yung filing date mo would be yung filing date mo dun sa original kung saan ka una nag-file. So that will be deemed that will be double your priority date. So in our ang receiving office ng PCT would be yung IPO na nandun sa sa jurisdiction mo, sa original jurisdiction mo. And then so this also allows other countries to file their applications here in the Philippines. Ayun, so we also accept applications from other countries. Ayun. So for PCT, mas lengthy yung prosecution. So again, after yung consideration dito is once you file it, you have 12 months before you can file for PCT. Ayun. So by the 12th month, dapat nakapag-file ka na ng PCT. And then yung in 16th month, magkakaroon ng international search report and written opinion from the International Search Authority. And then by the 18th month, magkakaroon ng international publication. And then dependent yung siguro by the 30th month, depende sa target area mo or target jurisdiction mo, mag-enter na siya ng national phase for that particular jurisdiction. Medyo lengthy siya, pero people do it, especially entities do it, or enterprises do it, especially if they really want to commercialize their product in a certain country and they want to seek protection, legal protection for their particular product that they want to commercialize. So yun basically yung PCT. So okay. Now that we have a patent granted, ano yung pwedeng mangyari dito? So it's still subject to various consequences anyway, kasi it's out in the public na eh, so people know about it. So it's still subject to invalidity, infringement, and you still pay annuities until its expiration date. And then it can be, however, don't fret, kasi once your patent can be granted, it can be used to assign rights, or you can license it out to third parties, depending on how you really want to use it. So basically, yan yung mga apat na main na nangyayari for patent once the patent has been granted. So, ayun, bakit nga ba tayo magpa-patent pa, ganyan? So, now that we know all the information about patents, bakit tayo magpa-patent? No, we want to stress this kasi for getting a patent would always signify quality yung work mo kasi it's evidence na your work is an improvement or your work is, I want to say, more inventive or better than that of what is already out in the market. So with this, it can be used to attract investment opportunities for your endeavor, and it provides a barrier to entry. Kasi when you have a patent, you're monopolizing a certain industry, a certain product within an industry. So ikaw lang kasi 'di ba, yung claims mo parang you're creating a barrier. So ikaw lang yung pwedeng gumamit ng product na yun, or ikaw lang yung pwedeng mag-exploit ng product na yun. However, yung disadvantages nga is, your product, yung description of invention will be out there. It's very much out in the open. And sinasabi na it's always expensive and it takes a long time and only enforceable only after grant. So now that we know the disadvantages of patenting, there are alternative solutions naman for this. So one, there's we call white paper. It's novelty destroying, but it can be used to equip competitors din. And we also have yung pwede ka mag-trade secret or NDA. Pero once na it's out there, pwede na lang i-reverse engineer ng competitors mo, and then it's difficult to track kung sino yung nagli-leak ng information. Ayun. So, depende, unless you wanted to have it used for public good, that can be also good. Pero once na i-patent din siya ng yung competitor, wala ka ng grasp for that particular technology for your own use or for your own exploitation. So, in summary, ano yung considerations natin before filing for a patent application? So we have to identify if it's patentable. So we have to check if it's novel, if it's inventive. We also have to check kung worth it nga ba mag-patent. So, and then, weigh mo yung pros and cons, like, ano yung makukuha mo once you patent? Will it be marketable? Or may market nga ba for this once you patent it? Like, would it may chances ba of licensing? You do preliminary market research, and then you check kung is there a need for this particular technology to be protected. And you also have to identify kung sino yung may-ari ng rights. If you're part of an organization, like how much of the patent will you own, or once you have it licensed out, gaano karami mapupunta sa'yo, or gaano karami economic gain na mapupunta sa'yo. And then, so essentially, ang use lang talaga ng patents is, again, protection from infringement. Kasi nga, you're monopolizing that particular technology. And it also really, like, we can't stress this enough, pero it also attracts investment from venture capitalists. And a patent portfolio can build your reputation, and is a barrier to entry for competitors. And it allows you to have licensing agreements or cross-licensing agreements. So that's for invention patents, kasi yun yung longest yung protection, right? So that's 20 years protection. For utility models, ayun. Meron lang dito, yung process na diniscuss ko kanina, that's for invention application, sorry. Pero for utility models, ang nangyayari lang, it's formality examination lang. Wala siyang substantive examination report. Formality examination lang, and then you have a registrability report. And yung prosecution is only around 6 months to 1 year on average before it can be registered or granted. However, ang protection nga lang is 7 years from the filing date. At walang central filing system for utility models, only inventions. And for industrial design, so ang non-prejudicial disclosure niya is 6 months as opposed to 12 months for inventions and utility models. And yun nga, 5 years ang grant, and it can be renewable twice. Ang only requirement niya is yung novelty lang. So, okay. Ayun. So basically, that's my presentation for today. Thank you for listening. I hope you learned something. And if you have questions, let me know lang.
All right. Thank you, Miss Andrea. So now we'll head on to the Q&A portion of her talk, which will be facilitated by my teammate, Ruchel. So guys, if you have any questions, feel free to ask away.
Okay, thank you, Ma'am Shore. Just like Ma'am Shore said, does any one of you has question, incubatees?
Don't be shy. I don't bite.
Okay, Miss Andrea, I will ask first. Baka shy pa sila. Okay. So, Miss Andrea, let's first discuss about the patent procedure. You've mentioned on how to obtain patent in PH, but uh, how much does it cost really in general? Para naman mag-gauge ng startups kung magkano all in all ang kailangan nila i-allot for filing.
Of course. I mean, pera, there's always money na kasama to, yes. Sa national phase, it's a cheaper din siya. Pero it also depends on like if you're a big entity or a small entity. But it's a lot cheaper for if you're a small entity or if your assets are under 1 million pesos. 100 million pesos. So, ballpark figure for when you're filing for an application, siguro 10,000 lang. But that's just an application. Iba pa yung annuities mo once it's granted. Ayun. So, depende pa yun kung gaano karami yung claims mo. And however, so that's for national phase. Ang mahal dito would be when you file for PCT or abroad. Kasi una, maghahanap ka ng representative doon. Kasi local, yung representatives here in the Philippines can't represent you abroad. Kasi iba yung laws that govern patent prosecution in other jurisdictions. So, ayun, and then iba rin yung fees nila doon. Mas mahal din. And then, apart from that, meron din fees for when you are to file PCT pa lang. So, siguro, you started 1 million pesos. But, don't fret, guys. May support naman na binibigay yung ICOFIL and other. DOS rin, they have support really for PCT applications for local inventors din. So, oh no, sorry, Ted. But yes, no, don't. Malaki ang support na binibigyan ng DOST and ng government agencies for filing for PCT abroad. So, hindi siya, once you have support naman, okay lang. And take note, DOST, hindi sila nanghihingi ng pera in return. Ayun. So, siya, like public service talaga siya. So, ayun naman. Since you're from academic institutions naman, I guess, you are, naman kayo parang pasok kayo sa criteria, I guess, for seeking for support. Anything else?
Okay, anything else, guys? Okay, wala pa. So, Miss Andrea, yun na, it takes a long time and then medyo mahal. So, for now, can incubatees discuss their invention with a potential investor before filing a patent application?
Well, yes. Oo naman. Lagi namang you can seek naman if there's really a market for it. Pero we highly encourage na mag-NDA kayo para hindi siya ma-exploit ng ating, in God forbid, but sana hindi siya ma-exploit ng ating VC. Pero okay lang namang okay lang mag-discuss with other VCs about your technology, especially if there's really a market for it. And then once that you secure funding for patent application, and then you can proceed. Pero dapat may precautionary measures ka to avoid any untoward exploitation, I guess, for your technology.
Okay, noted, Miss Andrea. We still have 5 minutes, guys. So if you have any questions, we can have at least 2.
Guys, sorry, like if I talk so fast, but I provide here. We really encourage people to ask questions kasi we really want people to learn din talaga about the processes and the importance of IP. Ang ano lang naman dito, laging issue naman dito is it costs a lot of money. Pero to be honest, hindi siya ganun kamahal, especially if you have a lot of economic gain. And it's better to have protection than none at all. Kasi let's say mapunta yung information na yun to any other entity that want to exploit that set technology for their own economic gain. Then lugi ka yung malulugi. Ayun. So ano lang, it's a precautionary measure, and it's your right. It's your right to exercise these. It's your, you have the right to exercise these rights. Ayun. So anyway, if you don't have questions, oh my gosh, so shy ba nitong overwhelmed ako.
Okay. Okay, Miss Andrea. Oh, I think shy pa sila. But in behalf of the startup, so bali, here in Cebu b.i.t.e.s, most of our startups are tech-based, diba? Yun nga. And then there are startups that rely on mobile applications. Can the apps be protected as well, Miss Andrea?
The apps themselves, okay. Ang maganda sa patents is you can have multiple IP rights for just a product. So for apps kasi, yung software itself, you can't have it patented. However, it can be copyrighted kasi code is a language, right? And any written work is copyrightable. So copyrighted yun. However, yung app itself, if it's part of a device, and then it has a certain function, you can have that patented, whether it's an invention or a utility model. And then the interface or how the app looks, you can have that patented as an industrial design. Kasi aesthetic features siya, right? Ornamental features. So yun, you can have several. And the more you have the more you build your patent portfolio, parang mas panatag ka siguro with like really putting your product out there. Kasi you have the protection. Yeah. Did that answer your question?
Yes, ma'am. Okay, let's have our last call for questions. Okay, incubatees.
Have you had your breakfast?
Once? Okay, going twice. Okay, since it's time na din, Miss Andrea, so I'll have my last question before we proceed with our second session. Bali, Miss Andrea, should the startups protect their brand lang or apply for a trade name protection too? Since, if yes, then why?
Trade name. Actually, yeah, whenever we do branding and the branding activities, we want to do both. Kasi any use really ng yung brand or ng yung, let's say, trade name, lahat yun magkakasama within a branding initiative. So you gotta have that protected kasi it's part of your branding. So you can't exclude. It's mutually exclusive, I guess. Inexclusive, I guess. Na dapat lahat ng kaakibat na branding initiatives mo magkakasama in one branding. One branding lang. Ayun. So, pwede rin yung trademark. It can be part of your patent IP portfolio. And one thing we do din kasi is we do IP valuation. So, you can provide monetary value for intangible assets. So, pwede mong ibenta yung rights mo and then may kaakibat din siyang money. So, ayun. Let's say, mayroon kang IP portfolio, you can sell it din naman.
Okay, thank you, Miss Andrea. So I hope that's clear to our incubatees. So aside from the brand, kailangan nyo din yung trade name nyo. Okay, so thank you, Miss Andrea. That's it for our question and answer portion. Ma'am Shore.
All right. Okay, guys. So I think I understand why some of you or most of you don't have. I mean, I'm pretty sure you have questions at the back of your head, but you don't know anong klaseng tanong or how you can exactly ask it. If one day or one of these days you will find yourself in a predicament that is related to intellectual property, please do not hesitate to contact Andrea Sidio by the ITSO office. Okay? Kasi I mean, as Andrea told us before, before this session, intellectual property is talagang heavy, okay? So they made sure made it possible that you can understand the fundamentals in just an hour para hindi siya mabigat, because it can actually take days to to understand it. It's actually even one subject in law school. So malaking bagay talaga siya. Pero at least you've got the gist of it, the fundamentals. If anything, we're here if you have anything more to ask. So I guess that wraps up Miss Andrea's talk from Pinoy IP Works. So before we head on to our next speaker, we'd like to ask a virtual group photo with Andrea. So I'd like everyone to please turn on your cameras. All right. Wait lang ah.
I think my video.
Wait, stop. All right. Okay.
I think my video is disabled. So
Your video is disabled?
yes,
Wait lang.
but
I have to start video. Is it good?
yes, but I hope you guys
Oh, yeah.
learned something for today. I mean, seriously.
Yes, so much. Dami.
So, just message them away. We'll answer them naman lagi. Really, really want to help din talaga, especially the startups. That's one of our, advocacies talaga to help you guys. So, ask away.
If you want, you can also read cases para maintindihan nyo. Pero medyo mahirap din. Very technical. That's the thing about it. Okay, so Kai, cards. All right.
That's Miss Short.
For joining us this morning. Such an insightful talk. So now we'll head on to introduce our next speaker. Okay.
Died.
Share screen. I'm sorry. Sandali. Okay, next part of our virtual session will be a talk from Engineer Gladys Christie Compasan, who is the manager of USTP's Innovation and Technology Support Office, otherwise known as ITSU. This talk will help you incubatees find out how the university can assist you in technology transfer and commercialization. So Engineer Glady is a licensed electronics engineer and earned her degree from Xavier University, Ateneo de Cagayan. She completed her master's in electrical engineering major in microelectronics at Mindanao State University, Iligan Institute of Technology. She is currently taking up her doctorate degree in engineering under mechanical engineering major in mechatronics at the same university. So aside from being the ITSO manager, Engineer Glady is also an instructor for electronic engineering as well as a research advisor here in USDP. So now I'll pass the mic to Engineer Glady so she can start her talk.
Thank you, Ma'am Shar. Good morning, everyone. I think I'm gonna have a quick talk na lang for us to really have it on time. And anyways, I think most of the participants already knew that we existed. I guess so. So if you don't have any idea yet, so basically the ITSO office is part of the technology promotions and commercialization office. If you want to visit us, we are here available in front of USTP. Hindi na kami nasa loob, nasa pinalabas na kami kasi frontliner daw. Okay, can you hear me okay, Ma'am Shore?
Yes, we can.
Okay. So basically, I agree with Ma'am Shore and with Miss Andrea that intellectual property thing is a very complicated thing, to understand and even to start it, But here, you have the b.i.t.e.s office that could really assist you in terms of your issues of IP. How are you going to do it? How are you going to apply? How are you going to manage it? No? Baka hindi nyo alam, no? You have an b.i.t.e.s and we are actually a franchise of IPOFIL. So what does the Pinoy IP Works services, what services were being offered, no? Services, the same services are also available here in it. So, and in fact, the office is also developing a curriculum for IP because we really like the vision of Pinoy IP Works and every IP sectors and institutions. We really want to promote or spread the knowledge about IP. Because this is actually what is trending now, no? So medyo nagte-trend na talaga yung IP, and so we want to spread the knowledge, and one way to do so is that we are actually developing an IP curriculum wherein all students, faculty members of the university can gain knowledge. And it's actually a subject. No? So 3-unit subject siya, mahaba-haba. It will take 48 hours in total to really give you a wide knowledge na of how does IP works. Okay, so I think that's one of a good motivation for all and to the students. No? So I will start my sharing. Can I share, Ma'am Shore?
Yes, ma'am, you can.
Are my slides clear? I'm sure. Is it okay? So basically, no, my role for today is to, again, I will highlight how important is IP, especially for startups, and how can TPCO here in USTP assist you, specifically the b.i.t.e.s office, because you know TPCO involves IP management and technology transfer. So we do two things, okay? So, but I guess for the startups, what we can assist is actually more on intellectual property. However, we do licensing. So in cases that you need assistance, as how are you going to license, knowledge about how are you to license your technology, we can also provide consultancy for that. So I think that's it. So I would like to start my presentation with what actually happened before. No? What actually happened before between academe and industry, and what's the reason why this office, TPC office, was established. So before we know, no, actually most people know that it seems that the academe is only for education, providing diplomas to the students, no? And we also have here industries who are into the market. No, they are more into business. Now, there are actually a gap between these two parties because industries, knowing that they are more market-centric, they look into their revenues, profit in their business. No? And they actually, with their business undertakings, they actually encounter a lot of problems, no? Because they do have their technology. The question is, how can they compete with the call for advancement of technology? Most companies actually have the struggle in that aspect. They don't know how to improve, no? They just know that they have the market, but how can they compete in terms of advancement of technology? And we have here the academics, actually one of the hub of innovation, research, no? We develop inventions, we create technologies, and before it was just put in a shelf, no? I think most of you here who are from USTP, like students who are doing their startups, I know you would agree that most of the research here in the university are just put on shelf, no? But we want to change that concept, no? So actually that gap is what we call the valley of death. So the university created technology which is not market ready. So it's just purely research, okay? And here comes your industry who look for solutions actually that could solve their problems, that could improve their product for them to be more competitive. So we want actually to change, to connect academia and industry, and that's why the TPCO office was built and established. In fact, it was just approved last May 2020, just this year. However, I would like you to note that the ITSO office, which is part of the units here in TPCO, already operated since 2015. No? So in terms of, we are actually doing good in terms of our intellectual property over the years. However, since we adopted this new era of innovation, which is technology transfer, that's why we created this office. And we mainly do two things. We do IP management, like what the Pinoy IP Works also does. And we do transfer of technology through licensing, okay? So that's actually the reason, that's the main reason why TPCO is established, because we wanted to foster innovation. And you know what? Innovation is nonsense if that invention cannot be used or utilized. No? That's actually the essence of innovation, an invention that is of use. No? If it cannot be adapted, if it cannot be used, then it's nonsense. No? There's no point of doing innovation. But however, would like to change that fact. We want to be more competitive as a science and technology institution. We want to address this need of innovation, and that's what we ought to do, okay? So currently, we adopted two major policies. In fact, this is a law, that's why this is trending, So the Intellectual Property Code of the Philippines, which is the RA 8293, and we have the Technology Transfer Act, which is the RA 155, and we adopted the same policy, because that's the general policy. Even the OST adopted that one. If you want to apply intellectual property under the OST, even DTI, they follow the same rules. Okay, we are bounded with the same rules and regulations, including the technology transfer. However, we just we are free to put additional in terms of institutionalizing the policy. So in USTP, we actually we established two policies in terms of the intellectual property incentive, because to foster innovation, we want to provide incentive to those who develop technologies that are IP-able. Okay. And moving forward, if those technologies are adaptable, so we look for industries who can adapt the technology, and with a successful negotiation, having a licensing, we also have a policy that provides royalty in terms of royalty sharing for the inventors who develop the technology that was made to the public. Okay, so that's it. I think that's a good motivation to us, to me also, to develop technologies that are marketable. Okay, so there are two things, So we have IP management and technology transfer. So like Ma'am Andrea mentioned, there are many IP that are out there now. So which are protected with this IP rights. So we have this patent, we have utility models, we have trademark, we have industrial and copyright. I just point out major players in terms of IP. And in terms of technology transfer, there are actually different ways we transfer technology. So it can be either through licensing, wherein we allow external industry to use, sell, or exploit our technology in terms of a licensing contract. So in return, we will be getting royalty. So that the same royalty will be the one that was institutionalized in our tech transfer policy here in USDP. Okay, so if you would like to ask how much is that royalty, that's actually the 60/40, which is the standard, the same policy followed and initiated with this act also. So we have also the outright sale. Kasi minsan, yung mga researchers ng university don't want to do business at all. They don't mind marketing their technology. So there's also an option that they will just sell their technology. So that's what we call outright sell. Pag wala ka namang motivation to really even do a spin-off or build your own company. So we also have another spin-off if the inventor really opt to create his or her company because the technology is really a market advantage, then we can also assist those inventors who wants to do spin-off. Okay, but take note that the technology was actually funded and sponsored by the university. Kaya spin-off siya because the development of the technology or the research was funded by the university, and we just assist these employees or this researcher to build their own company from that technology and gain market advantage. Okay. Another is joint venture if we do partnership with industry starting from the development of the technology until the exploitation of technology. So basically parang partnership siya. So those are common ways how we do technology transfer. And these are common IP that we protected, okay? Here in the university, kasi ito yung mga common. All right, so if you'd like to know where is our office, we are here located in front of USTP. We also have our own website, which was just launched, no? Parang kailan ba yun, Ma'am Shore? Nasali kami doon. Okay, so yung USTP Innovation Tech Solutions.com, tapos sa PPCO, andun kami doon. Feel free to check what are the services offered, how can you contact us, but if you opt to meet us personally, we are just right here, okay? And the organization, so the TPC organization, we were led by our director, Dr. Vanessa A. Garcia. We are in the system level, so basically we are directly reporting to the president, and we have 4 units under the office. So we have the b.i.t.e.s, the unit, intellectual property, does IP management. We also have Ma'am Monica Mabaylan, who is leading the promotions. And we also have Ma'am Vanessa, who is also a concurrent business development manager. Now, I'm pretty sure in your incubation program, you were also trained to how to create your business model. So here in TPCO, we also develop business models especially for new technologies and for a company who wants to venture in a new technology. So we develop business model for that. We can assist. And we also have here another unit, which is contract management unit, who monitors, execute all the contracts involved, starting from the IP and leading to the technology transfer. So again, we just follow standards, policies, law. No? That's why we develop such unit to really implement everything properly. So I think that's it. And for the innovation and technology support unit, basically the b.i.t.e.s. So I have 3 main technical experts who are really expert in their field for engineering, for technology, and for computer-related inventions. I also have one who is about to join with the team for the food-related technologies, and we have some stuff. What are services that we offer? We provide IP consultancy. We assist and conduct technology non-disclosure. So let's say if you are about to do pitching, we would like to advise if, especially parang may nakikita na kayong investor nyo to initiate non-disclosure agreements or yung NDA. We could also assist on that. We could also assist if you want to do it with yourself, the conduct of prior art search or the patent search, like what Ma'am Andrea mentioned a while ago. We could assist, and we also could conduct that for you. No? And in terms of patent drafting, we also do that. We do IP clinic wherein we conduct assessment as to how mature is your technology, how is it really prepared in the market. So pag prototype lang baka kasi iniisip nyo pag may prototype na, oh okay na, it's okay to play in the market. No, not yet. So there are stages of assessment. So the clinic there aims to assist you how to make your technology more mature. We also conduct trainings in terms of IP awareness, IP foundation. We also conduct IP and technology evaluation. No? So lalo na pag isi-sale nyo yung technology nyo, no? Na naka-IP na. So we assess how valuable is technology. It's just not directly or purely saying pricing. It's more on that. No, it's more on that. It's purely defining what is the value of your technology. And I guess even looking into the price, no price could beat that. So, but we initiate defining the value of your technology. Okay? We also assist in your IP application and management. Kasi medyo madugo. Sometimes kasi pag na-apply na, okay na kasi naka-apply na ako ng technology or ng patent, but it doesn't end there. So you have to manage your IP para hindi ka mapasok. Okay? So we do that. We manage because again, we are a franchise of IPOFI. Okay? So here's also the promotions management unit, the services. We promote technology, we maintain technology profiling, like how are you going to do your IP profiling, no, in your own business, in your own company. We conduct linkage activities between industry and academe. So because we want industries, we want the public to know that we exist. That's what we want to do, okay? We also conduct, again, technology and IP evaluation for the industry. In terms of business development, we do market landscaping and assessment. So basically, we want to provide information to the industry. How big is the market? How can you play in the market? And we also conduct assessment in terms of technology transfer. So we also look into checking if a certain industry is really enough capable to market said technology. Because of course, as a university, we want our technology to be well utilized. No? So we don't want to transfer technology to industry who just want to start new and then after that, wala na. No? So we assess your capability as well. For contract management, mostly attorney kasi yung nag-handle to. Currently is attorney Kim Fiso is doing the CMU. The execution of the agreement, monitoring of agreement, if may breach of contract ba, or are you doing your responsibilities as part of the party of the contract? Are there infringement cases involved already? So mga breach of contract, ganyan mga cases. Pang medyo attorney siya. Okay, so if you try to look at it, we are composed of technicals, promotions, business model expert, and a lawyer. So medyo full package kami ngayon. Okay, so I would like now directly to go into how important is intellectual property, especially for startups. No, I will start this with this story. Alam niyo yung if you could have heard the case between the I4I Partnership Incorporated versus Microsoft Corporation. So, isa siyang malaking kaso before wherein actually the I4I is just a very small company. Parang nagsa-start lang din siya like you. So what happened is that they are the ones who actually developed the XML formatting. Okay? So, and then here comes a Microsoft Corporation through their Microsoft Word where they can do or they can edit XML files. So with that, the company I4I filed for infringement against Microsoft Corporation for infringing their patent. Okay? Because yung XML kasi patented na siya, no? So because of that, no, the case was decided, held in US. And it was decided that the Microsoft Corporation really did infringement. And because of that, $300 million was paid. No? So what I would like you to learn from this story is that I4I is just a startup like you. You know what? Big companies look into small or startup companies because startup companies are the ones who are very eager. Actually, they are the ones who are very eager to look into new inventions. And yung mga startup kasi mention, walang alam sa law, no? So parang, sige, you are pitching, you are introducing your technology, not knowing that they are already stealing what is yours. So, and one way to do that is you file for intellectual property for you to be protected, no? So pag-aabot kayo sa case na parang kinopya yung invention nyo, and knowing that you are already IP protected, then you can sue that company for infringement. So that's the lesson, I guess, that I would like you to learn from this case. And because of that, no, so since you're starting your company, I want you to start it right. So I guess everybody would like to agree, even Ma'am, sure. I want you to start it right, and how to do it: follow rules, follow legal standards, and seek help. Okay, so like what Ma'am Andrea said. So with that, no, I would like also to introduce this kind of a diagram wherein most businesses actually made their company very successful because they have these three main factors in their company. One is that they have their technology, they protect their technology through IP. They even have their business process or method. You know, business method and process are also patentable. Okay, the business process itself is not patentable, but if a business process implemented such that you produce certain goods, tangible assets, then that can be patented. Okay, so you can protect your business model. You feel secure with your product. You feel secure with your business method. You follow law. You follow what are the national regulations. You actually became very competitive. I'm telling you that because from small to large industries, these are actually the main factors for them why they are successful. Okay. And so why is it again very important? So I would like you to realize this statement that intellectual property or IP is one of the ways you can protect yourself and help you grow your business. So these are, I think, the four major significance in terms of IP. Number one is legal protection and legal rights. So IP is all about protection. So, and you, which actually avoids other, or example, your competitors from exploiting your technology. So, diba, if you sell a product or you sell a services, one way to make it really your own is to protect it. Because once you protect your product, including your services, that can be your own, no? And you refrain others from using, exploiting, selling, distributing your technology. Of course, market advantage. Kasi like sinabi ni Ma'am Andrea, minomonopolize mo na yung technology na yun. So, especially pag yung technology mo trend, parang magti-trend talaga siya. And you can really see a potential that this kind of technology will grow, no? Alam mo yung Apple, di ba? Parang dati, ni-reject yan. It have been rejected many times. And then now, where is Apple placing in the market? It's actually the top one in the market, okay? In terms of how valuable is their company, their brand, no? So looking into it, no, if your technologies are IP protected, you can gain market advantage because it will be, you are monopolizing the technology already, okay? Also, for startup, this is a good thing. You could attract investors. You know, like if you look into the inventor's mindset, what they always look is how you value your asset. No, valuing the fact that you value your asset by protecting it, the inventors will consider you as a very credible company. No, because you started it right. No? So it would be good to say that if you want to showcase your technology, you will say that this is already patented, this is already protected, and I can assure you that you are investing in a company that is worth to invest. Okay, something like that. No? That's good to know. Another is generate revenue, because there are other ways wherein you can gain income out of your technology. You can also license it or franchise it. Okay. And I think these are the four major factors that why is IP important, especially for you, no, for startup companies. And there are actually issues, no? We recognize important siya, pero maraming issues. Una is wala kayong in-house resources, no? So even you don't have general knowledge about IP, no? So because you don't have resources, medyo tatamarin ka, I don't want to go in that process. I don't have money, no? So you fail to file your invention. And you even have a difficulty in finding experts, right person to approach, no? And for you to, again, to know we are here, no? The ITSA office is here. And sometimes then mabigat sa bulsa yung initial expenses ng IP. Like what Ma'am Andrea mentioned, there are many government agencies do funding. And another is you get into the jungle of national regulation. So parang napasok ka isang malaking bagay, no? So we don't have knowledge about law. We don't know that ay nasa policy pala ito. So kasi even like they said, ignorance of the law excuses no one. Once you infringe something, you can be sued. So you have to be careful also, not just protecting your IP, but ensuring that you are also not copying something that was owned by others. No, it's just not about protection, but refraining you to do infringement. So yun siya. And then another, again, no resources that could manage your IP. So I think all these issues, we can address this one. Okay? And so how to start? Okay? So ngayon, andito ka. So you just started, you don't have knowledge. No? Number one is you engage in an IP agent or expert. So come into the ETSO office, talk to us. Okay? Second is, in your side pa lang, sa side niyo pa lang, identify your IP. What are your assets? Kasi maraming types of IP. Yung trademark mo, yung brand mo, baka yung design ng technology mo, including the technology itself, your solution, the solution that was introduced. It could be the product, it could be the process. No? You also have programs, you can do copyright. No? So identify your IP. Then also, is research also about your IP? So baka may kapareha ka, no? So you're giving more effort and then just finding out na ay nag-i-infringe lang pala ako. Parang nagaya na lang pala ito, no? So also give yourself a moment to do research, no? That's actually research all about, no? Literature, okay? So you have all the IPs, you know that your technology is have a potential to be IP protected. Second, fourth one is pick your IP battles. No, so among those IPs, pick which is very which needs to be prioritized. No, saan ka magko-compete? Kasi magastos yung IP. Alam niyo naman yun, di ba? So pick which is the best to protect first. Okay, pick your IP battles wherein you can compete in the market. Okay, and then others will follow. And fifth, ito din yung sinasabi ni Ma'am Andrea, avoid enabling public disclosure or EPD. So I believe you are doing pitching activities already. You are even talking to investors, no? Ito yung common mistakes ng mga startups. You know, yung researcher kasi eager to share their information because they want the person that they are talking to really have that sense of security na ay napaka-expert na pala nito, dito ako kasi expert siya. Parang ang dami mo nang sinasabi to the point na kaya na pala siyang gayahin ng iba. So yun yung enabling public disclosure. So as much as possible, I mean this is mandatory, avoid doing that. So you can share part of the information that not to the point that it is already enabling. That's the keyword. Avoid sharing na enabling na siya. Okay? And then second is also protect also your IP from investors. Hindi naman dahil sila yung nagfa-fund ng company mo, so you are open to share. Remember that you are the inventor of the technology. You are the owner of the technology and siya lang nung nagfa-fund. Tendency kasi, investors come and go. They don't stay lifetime, no? So posible kasing i-apply niya yan, siya yung mag-o-own, naunahan ka na. First to file siya, remember, diba? And then, protect also your IP from your employees and even your contractors. So, nagsa-start up ka lang, you are hiring employees na already, no? Even those employees, kahit friends mo, they come and go. Friends come and go, no? So, protect what is yours. Yun lang talaga. So these are just initial strategy that you can do with your own. Okay? And after doing that, I would like again to highlight what are those IPs. No? Marami kasing IP, di ba, na mention ni Ma'am Andrea. But I would like to highlight what is the very common applicable to startups. Number one is patent. Yun yung talaga yung invention mo. And Ma'am Andrea mentioned there are many criteria for it to be patentable. It should be novel or new. It should have an inventive step. Yun bang yung may wow factor na parang you would not expect that this will become something like this. Yun yung ganon. So it's something that it's far from its normal, no? Kaya ano siya, parang invented lang siya because you cannot imagine that this would be gone something like this, ganun siya. And it should be industrially applicable. So industrial applicable meaning dapat kaya siyang gawin, kaya siyang i-manufacture. Imposible naman kasi gagawa ka ng technology, ikaw lang yung kayang gumawa nun. Hindi siya pwedeng ganun. Okay? So copyright also, yun yung any written works or creative works that you have made in your company, including your manuals, your brochures, yun, pwede siyang i-copyright. Yung program nyo sa pag-software enabled, yung technology nyo, yung program itself can be copyrighted. Yung system, yung buong system wherein you integrated the hardware with that program, that can be patentable. And the trademark, kasi importante ito yung startup, yung branding. Kasi minsan, ang iniisip lang natin yung technology. You also have to, since you're starting your company, initiate your brand. That's way of trademarks. No? And more on trademarks. So I guess patents was already clearly discussed by Ma'am Andre, but I would like you to discuss more on trademarks because importante siya sa nag-start branding. So your company can also be trademarked, no? Product name can be trademarked. Your logo, even your slogans can be trademarked. What's the importante kasi yung trademark, lahat ng aspect ng company mo, lalo na nagsa-start ka, dapat iti-trademark mo na siya. Company, para alam nila, example, Jollibee, alam nila yung Jollibee is ano siya, for food, restaurant, no? So, like yung Nike, alam natin, shoes yun, no? So, yung Apple, phones yun, computers yun, McDonald's, restaurant yun, gano'n. So, yung company name mo mismo, register it. The product name, kasi minsan ang tao hindi alam ano yung name ng company, but they know the product. Okay? Sometimes kasi way of promoting, if you protected your product name, alam ng tao kung saan nanggagaling yun. Lalo na yung kung product mo is napaka-click talaga sa market, no? Kumakain tayo ng siomai, hindi rin natin alam, siomai sa tisa pala yun, no? So, parang hahanapin mo ngayon, saan yung siomai sa tisa? Kasi natikman nila na yung product mo naka-siomai sa tisa, hahanapin nila yun, no? Yung logo, pag nakita nila yung like ito, yung sa Apple, yung Facebook, yung Louis Vuitton, so alam niya mga one of the credible companies to kasi naka-trademark na yun. So pag Apple, naku, napaka ganda ng products nila diyan kasi Apple yan, ganun. So even your slogan, alam niyo yung kahit yung sa SM, we got it all for you, di ba? So naman yung nakapunta, halos lahat naman sila nakapunta sa SM, no? Tapos yung McDonald's, I'm loving it. So pag nakita mo na, ang sarap siguro ng McDonald's. Kasi, di ba, sikat sila, ganun. Yung Nike, just do it, yung ganun. KitKat, sabi ko, have a break, have a KitKat. KitKat yun, kasi alam mo, di ba? Yung something, yung slogan, even yung slogan mo, kasi that's way of promoting also. The more you became more visible in the public, the more that your company will be trending. Magte-trend siya, okay? So that's trademarks, very important. So what are different types of trademark? I guess na-mention na naman ni Ma'am Andrea. So it can be arbitrary or fanciful, suggestive, descriptive, generic, no? But again, yung generic is not patentable kasi common siya. However, there is a case that a generic trademark can be protected if it achieves a second description or definition or secondary meaning. So sometimes like example, yung Cartoon Network mismo, di ba? Napaka-generic yun. Cartoon tsaka network, generic na kasi yun. But it became registered because pag sinabi ng bata, gusto ko ng Cartoon Network, automatically alam ng parents na ano yung Cartoon Network. So naka-gain siya ng second meaning. Yun yung ibig sabihin niya. So it cannot be protected per se because of its generic name, but because it gains secondary meaning. So they avail protection out of it. Kaya yung, again, balik ako sa arbitrary and fanciful. Yun yung parang you don't, the logo doesn't directly refer to its services or goods. Like yung Apple, imagine yung Apple tapos may b.i.t.e., di ba? Who could imagine na computer pala yan? No, so, actually yung Apple, low marketability kasi yung ganong type na trademark. Kasi you will not, by looking at it, you don't know what the product or the services it offers. Ganon siya. However, yung Apple, nahirapan sila actually i-market yung product niya. But eventually, naging sikat sila. And they protected their trademark. So, kaya yung brand value ng Apple, top 1 siya sa Forbes na data. Yung Kodak, no? So, hindi kaya nga, diba sabi ng lolo, oh, magpakodak ka na, magpakodak ka. So, photography yon, but it doesn't simply say nga photography siya, di ba? So, fanciful siya, arbitrary, mahirap siyang i-market, pero mataas yung protection niya kasi rare siyang gayahin. Yun siya. Suggestive, it could be fairly marketable, fairly protected. So, yung Netflix, for example, ano ba ibig sabihin ng Netflix? Di ba? Yung services nila is they offer online streaming of movies, no? So they use the online platform for you to rent in a subscription base. Kaya yung Netflix, ang meaning niya is network, meaning it uses internet. Flix, yun yung concept of streaming, no? So meaning you are streaming movies using internet. So suggestive lang siya kasi it doesn't explicitly say something, but it has a meaning. Okay? So yun yung suggested. Though madali siyang i-market kasi medyo naman siya nakikita naman nila na ay internet yon, tas movies yon. Tas kaya medyo mapoprotect din siya kasi hindi naman siya common. Even yung Microsoft, ito yung microcomputer and software. No? Yung descriptive, highly marketable siya kasi pagbasa mo lang, alam mo na ano yung goods, ano yung services, like Sharp. Alam mo TV yon, no? So descriptive siya, though weak yung protection niya kasi nagiging close to generic na yung term. However, again, may exclusion na you can trademark that if you can gain secondary meaning. Yun yung nagiging, because the consumers, the users, the client, the customers have been using it, and then if they heard Sharp TV yun, so nagiging distinctive ka na because of those secondary meaning. So there are two ways lang talaga for you to do trademark. Number one, it should be visible, and second, it should be distinctive. Yun yung two main factors. Lalo na pag nag-create kayo ng logo nyo, yung company name, so look at it. Alright. So ano yung function ng trademark? Kasi sa startup, importante yung trademark. Almost the same with the invention actually. You could have a territory, no? So pag sinabi kasing let's say SM, yung sa SM, saan ba yun? So may andun sa Uptown, no? SM exists as in parang sa globe na ata siya, no? So you gain territory, you gain identity, no? So you even have an extension through licensing kasi yung trademark mo kasi pwede naman siyang i-license or i-franchise. Kaya nga yung McDonald's, no? So yung nag-a-adapt, nag-franchise ng McDonald's, including their logo, na-a-adapt sila because yung logo niya, yun yung nagpapa-trend sa kanya. Kaya nakikita siya sa public, known siya sa public, even mas pangmasa na yung restaurant na yun, no? So it comes with the brand, it comes with signature. So I would like you to share this one, top 10 most valuable brands. So itong mga brands na to, they started very small. They started like you, no? Yun. So yung Apple siya nung top 1. So imagine, before kasi 2019, second lang yung Apple. But in 2020, siya na yung top 1. So yung brand value ng Apple, napakalaki, 241.2 billion. Tapos yung Facebook, alam nyo, top 5 yung Facebook. But kailan nagsimula yung Facebook? Di ba parang hindi naman siya ganun ka-obsolete kasi nung college na ako, wala pa akong Facebook. Diba? Tapos bago lang talaga siya, but it came into the 5th place, imagine. Parang mas naunahan niya yung McDonald's, na parang matagal na yung McDonald's. So ito na yung mga napaka-top gaining high revenue in the economy. Okay, and so another way also for your startup, pag you can also license, no? Meaning pwede mong i-allow other party to sell, to create, to distribute your technology, no? So it's through a contractual agreement. So may kontrata kayo dapat, no? And there are different types. You can license your product, no? Your invention, you can license that. Your trademark, you can license that, including your copyright works, no? You can also license that. So what do you mean by licensing? Importante kasi siya, lalo na yun yung nag-i-expand na yung company mo. So ila-license mo siya kasi revenue yun. Kikita ka out of licensing. Okay? Baka mga 2 years from now, no, mag-i-expand na kayo, so better use licensing. Anyways, in cases that you need assistance how to do licensing, we also assist. Okay? So how can we assist you? Yun na yun. So as of the moment, kasi hindi pa naman kayo nag-i-expand, nag-start pa lang kayo actually. So IP protection and management muna tayo. So we have here the b.i.t.e.s. We are franchise of the i.e.s, no? So our main again services includes consultancy, patent search, patent drafting, training, IP validation, IP clinic, and overall IP management. So the b.i.t.e.s office in USTP was again established since 2015. And our goal is to really strengthen local institutional capacity to access the patent information. And we don't only serve university, we also serve external clients. So in fact, we've been doing the same services from external clients here in Cagayan de Oro. And we also have customers from Camiguin, we have from Ozames. So we're quite visible already, okay? So what else? So in terms of filing, so kanina kasi ina-ask niyo how much does it cost? No, actually, this is the standard under the IPOFIL. You can actually visit the website of IPOFIL, ipofil.com. The same, how much does it cost to file a patent? Ito yon, okay? However, it doesn't account the services, including if you want us to do the patent search, the patent draft, iba yun. Ito kasi is the filing fee na already. So what are the requirements if you want to apply? You can approach the b.i.t.e.s office to assist you in filing. Just prepare the fee. Kung ano siya, invention to, no? So again, nagdedepende siya pag small entity or big entity. So nagva-vary siya, kaya mas mahal yung big entity, no? So kayo startup pa lang naman, you can use the small entity. So what are the requirements? Just fill out our b.i.t.e.s request form, because again, we have different services. We do consultancy, we do patent search, we do patent draft, we do patent application, we conduct IP evaluation. So just check which do you need, okay? And then provide us your specification or description. Yun yung complete and detailed enabling description. Yun yung sinasabi ni Ma'am Andy Yang, it should be understandable as much as possible. Importante yung claims kasi yun yung nagiging, yun yung kinoconsider mo na unique na galing sa'yo. Yun yung invention mo. Kaya kiniklaim mo siya as yours. And then provide us the abstract of your invention. Yung abstract kasi isa siya sa pinaka-importante, lalo na pag nakakanda kami ng prior art search. And then drawings if applicable. So labi na pag technical yung mga technology nyo, more on engineering related. So drawing is very required. Tas yung you have to fill up the invention or the patent application form. The same requirements goes with the utility model kasi minsan naman kasi mas madali kasi gawin yung utility model, yun lang. Pero mas mabigat actually yung protection is yung patent. So the same requirements, just fill up the application form also. Mas mababa yung fee ng utility model. Kasi what's the sense naman kung mahal is 7 years lang naman yung protection. Parang ganun. Okay? As to you, no? Minsan kasi yung invention ngayon sa mga students more on utility model na. Kasi nag-fail sila sa isang criteria na yung inventive step. Yun yung wow factor, di ba? So, pag hindi ka hindi mo na-meet yung requirement na yun, utility model ka lang. However, kahit utility model siya, tapos nagpipitch na kayo, you should apply your technology and pay for the registrability report. Yung registrability report kasi, it doesn't mean that your technology is already protected. Nasa process pa siya. But you have an initial enforcement of right. Okay? So, lalo na pag nagpipitch kayo, nagdi-disclose na kayo ng information. So, dapat naka-request na kayo ng registrability report kasi para siyang partial enforcement of your right. Yun. Okay? And trademark filing. Ito yung ngayon halos dami naming trademark na fina-file. Kasi sa USTP, ang daming naglilipara ng mga logo. Yung sa DTO, yung USET, HRIS, no? Yung sa ITSD, yun, fina-file namin yun. So, ang requirements ng trademark is just again fill up the request form. You have to fill in the contents in the application form of trademark. Provide us the JPEG file of your trademark. Provide description of your drawing of your mark, and then you also have ito in-advise namin siya kasi yung trademark minsan napapaso siya. May may requirements sa trademark na after 3 years, you have to file the declaration of actual use. Yun yung proof na talang ginagamit mo siya. Kasi pag hindi ka nakasubmit nun, it simply means na hindi mo siya ginagamit. It's not applicable. Okay? So, i-delete siya doon sa system. So, hindi magiging public domain na siya. So, that's why ang ginagawa namin, kung ginagamit mo na talaga siya and you want to use it already, the moment you apply for the trademark, also apply na directly the declaration of actual use, at least for the 3rd year. Second kasi payment is yung sa 5th year na every 5 years magbabayad ka for the declaration of actual use. Yung trademark actually, di ba, like sinabi ni Ma'am Andia, 10 years protection siya but renewable siya. So again, in-emphasize ko yung trademark for startup kasi yun yung brand mo. So you have to make your company known to the public. That's way of promoting your company. So I think that's all, Ma'am Shore, and I hope I provided advices, insights to our startups. And feel free to email me in case you have questions or you need assistance. I think that's all.
Okay, thank you, Ms. Gladys. I think we have some questions. So let's proceed to the Q&A portion, which will be facilitated by Ruchil again.
Okay. Hi, Ma'am Gladys. Okay, incubatees, we will now entertain questions for technology transfer, licensing, and commercialization. Who wants to go first? Okay, let's see. Any representative from Checkmate? Dirtbag. J-Create. Okay, Tisuan Sanitizer and Medcon is not virtually around. So, last but not the least, Ihatid, do you have any question? Or from our guest, Luminaries Handicraft? Okay.
Actually, ang Luminaries, wala na ako na-change yung name sa Ihatid.
Okay. Sige. Ma'am Gladys, sige, I'll go first. Baka later on they'll have questions. Okay. So Ma'am, Miss Gladys, we would like to know how long or how many years ba does a certain type of an intellectual property protection in the Philippines last?
How long does... yun yung minention kanina ni Ma'am Andrea na each IP kasi limited lang yung protection, di ba? Let's say yung patent, 20 years lang yung protection, yung utility model, 7 years lang, yung trademarks, 10 years, but renewable siya. Yung copyright din, 50 years, no? Tas after death. So yun lang yung with that span of duration, doon ka lang protected talaga. So, I think that's it.
I see. Okay, ma'am. We have here a question sent privately. Okay, I will read it for you, Ms. Gladys. Since investors have a huge role in sustaining startup, they can even be part of the incorporators if the startup register as a corporation. Right, Ms. Gladys?
Mm-hmm.
And then, however, if the startup has intellectual property protection, does the privilege or right extend to the startup startups investors, or does it protect the startup and its founders from having ill-intentioned investors from stealing their ideas?
Okay, so it depends on what is the mode of your acquisition. So, paano ka binili? So, of course, you have that contract. Kung alam mo kasi na may asset ka and you will be funded or you will be absorbed by a certain company, declare what are yours first. So, pwede naman kasi nyo i-state nyo during sa acquisition na minsan kasi sa amin sa licensing, lalo na pag owned by USTP, tapos ita-transfer namin sa industry, sa contract namin, nilalagay namin na any intellectual property owned by the university stayed within the university. Okay? However, during the migration, during the acquisition, if there are inventions developed during your partnership, yun yung magiging joint. Okay? So careful kayo doon kasi sinabi nila, binili ka namin, so akin na, depende yun sa terms kung paano nyo binili or paano nyo pina-acquire yung company nyo or paano nyo pina-invest. You could offer all property, all your asset to be theirs also. No? Depende again yun sa, but we would like to advise kasi nasa law yan. Nasa law yan that you can declare kasi the moment na naka-apply ka, yung IP mo directly, ikaw yung owner nun. So, ikaw na yung owner, nobody owns it, except you. Kahit na bibilhin ka ng isang investor, the invention stays the same as yours. So, I would like to advise, in your contract, you should have a clause there in your contract, in your acquisition that may first party intellectual property, second party intellectual property, and joint intellectual property. Yung joint, yun na yung mga technologies na isa-share niyo dahil nag-merge na kayo. So yun. So kaya be careful kayo doon, medyo tuso. Yun yung mga tawag natin sa mga big companies na nag-acquire mga patent trolls yun. Parang bibilhin niya tapos yung purpose nila is kukunin lang nila yung invention. Yun yung mga patent trolls. Okay, so I think that's it. I hope I answer your question, ma'am.
Yes, ma'am, definitely. Okay, so incubatees, please take note of that. Okay, any other questions? Last call for questions. Incubatees, going once, twice.
Na ako'y question.
Okay, go ahead.
More on sa previous na startup which is still ongoing naman karon sa Veggiefish. Possible ba kanang, since you mentioned nung protected ka sa Philippines, but what if are you prohibited from patenting technology na already patented outside of the Philippines and may mga overlaps, may overlaps lang siya, may mga features na similar but not entirely, hindi siya the same talaga.
Okay, sir. So I think yung question mo, what if yung technology nakapatent na sa ibang bansa, then you want to patent it here in Philippines? Yun ba, sir, yung question mo?
Yes, and the technology is not entirely the same. Parang improvisation siya.
Okay, so una kasi, question muna natin is patentable ba yung invention mo? Doon muna tayo prior sa rights na. Okay, you still go to the process of checking the novelty, the inventive step, and the industrially applicable. So knowing na nag-exist na siya sa lahat, kahit improvement na siya, possible kasi you will not pass in the criteria of inventive step. Hindi na siya, kasi obvious na siya, kasi ginawa na siya. Kasi yung technology sa labas, yung prior art search natin, yung i-compare natin kung nag-i-exist na siya, hindi lang siya national ha sa Philippines. Global yon, yung prior art natin global. Yung technology sa lahat, chine-check din natin siya as prior art. So kung nag-exist na siya sa labas, close ka na sa inventive step. But you could still pass in the novelty kung may bago talaga siya. So in that case, utility model lang yung ma-IP mo. So given that na protect ka na sa utility model, your rights is territorial. So protected ka lang dito sa Philippines. So kung i-infringe dyan naman yung technology mo sa labas, sa ibang bansa, you are not protected there. Okay, so kung i-infringe niya, you cannot sue them kasi yung rights mo andito lang siya sa Philippines. So kaya yung sinabi ni Ma'am Andrea, go for PCT filing. Kung feeling mo naman, by landscaping your market, kung makikita mo siya, may possible ka to gain market internationally, then go for PCT filing.
All right.
So I think yun po. I hope I answered it right or clear. Sige po.
Thank you.
Okay, thank you. Any other questions?
Shy
Okay.
type din.
Sige, I think it's 12 na din, Miss Gladys. Okay, so having none, if our incubatees or startups has a let's say questions later, or they want to avail the services of b.i.t.e.s, how can they reach you or b.i.t.e.s?
Yeah, I showed my email actually in my presentation. Anyways, I will send my presentation naman to my short kasi parang mandatory naman. And you can visit our website, yung sa Innovation and Technology Support Division website. Then my TPCO doon, look for our contact number there. And if you really feel going to us personally, we are just here in front of USTP.
Okay, thank you so much, Miss Gladys. That's it for our question and answer portion. I will now give back the virtual floor to Miss Chor.
Okay, so we've come to the end of our fire session. I hope that our incubatees have realized how critical intellectual property protection is to fostering innovation. Without protection of ideas, businesses and individuals would not reap the full benefits of their inventions and would focus less on research and development. When a startup protects its ideas, it is consultancies with USTP's b.i.t.e.s, among others. And as mentioned by Ms. Andrea earlier, once you are a registered startup in the Philippines, the DOST can also help you with this matter as well. So in behalf of CDO b.i.t.e.s, I would like to thank our two esteemed speakers, Ms. Andrea Cuevas of Pinoy IP Works and Engineer Gladys b.i.t.e.s, who took time of their precious weekend to talk about intellectual property with our incubatees during your respective virtual certificates of appreciation via email. So with that said, I would like to ask everyone, turn on All right. All right. 1, 2. Wala. Okay. All right. 1, 2, 3, smile. Okay. So, Miss Gladys, thank you so much again. Okay.
Thank you, Ma'am Shor.
So, thank you, Kayo. So, reminders before we officially conclude this session. Please take note that one of your new milestones as incubatees under the Firestarter Incubation Program is to be registered. Dapat before mo mag-graduate, registered na gid mo. So make sure to register your business with DTI and or SEC, especially since nowadays investors are particular with registered startups. Free legal consultancies are still ongoing every Sunday upon appointment with Attorney Albert Daba III. So please maximize this opportunity. Free yung legal consultancies niya. So just make sure that you can book it. Sunday evenings daw siya available. So another milestone, new milestone aside from being registered, is please consult with ITSO or Pinoy IP Works whether or not your startup is qualified for intellectual property protection. So if you are, please make sure that you apply for one. We want you to do this because DOST also asks if you are protected or not. So the last reminder, the next fire session will take place on November 7, as we will take a break next week to give way to those who will be observing Halloween, All Saints Day, and All Souls Day. So I hope everyone had an interesting morning, especially since it's about intellectual property. I hope you learned a lot. So that's it, guys. Thank you very much. Enjoy the rest of the weekend. See you in November. And please keep posted with our activities, especially since November will be a very busy month for us, okay, for the startups. So keep posted. Thank you very much, everyone. Good day and enjoy the rest of the weekend.